All right, I'm showing 6:30. Staff ready? Great. All right, the time is 6:30, so I'm going to call to order the February 6, 2020 Board of Zoning Appeals meeting. We'll have a roll call to determine if there is a quorum tonight.
Clark.
Here.
Falvey. Here. Gardner.
Here.
Harrod. Shalinski.
Here.
Wampler.
Here.
Weisner.
Here.
Thank you. We have quorum.
Great. Item number B here, do we have any communications that need to come before the board?
We did not receive any additional communications other than the ones that you have in your packet.
Do we need to disclose any ex parte communications or abstentions for specific agenda items tonight? Okay, seeing none, are there any agenda items that will be deferred?
We have no request for any deferrals at this time.
Great. Item number C, the minutes from the meeting for January 9th, 2020. I would entertain a motion to approve those meetings.
So moved. Second.
Second, I have a motion and a second. All in favor? Aye.
Abstain. I wasn't here.
Opposed? Motion passes. And we will now move on to the public hearing portion of tonight's meeting, starting with the only item, item number 1, B19 453, an appeal out at 6th and George Williams Way. We'll hear from staff.
Good evening, Commissioners. Catherine Wheat, one of the planners in the Planning Department, and I'm here to present the administrative appeal item that you have before you tonight. Again, just the matter that's before the BZA this evening is strictly the administrative appeal, and that is, did staff err when it issued a written determination which stated that plating is required prior to any property receiving a building permit as required by the Land Development Code. The code section in question is 20-801C2, which states that the property within the incorporated city limits of Lawrence, no building permit shall be issued unless the property is platted as a lot of record. Unplatted property is ineligible for a building permit as shown by the compiled code sections and definitions. The sign proposal to erect a freestanding monument sign constitutes development activity. It is a structure and requires a building permit. The property must therefore be platted before a building permit may be considered or authorized. Staff has not erred in the determination that the submitted sign proposal was ineligible for a building permit, since the land on which it is to be located is not part of a recorded final plat. Even the reasoning in the stated appeal that the applicant has provided is that the property is in fact not platted, and that property can only be issued a building permit, or a building permit can only be issued on a platted lot, and that the lot will remain unplatted until such time as it is developed. And staff is contending it is being developed with the request for a sign to be located on this particular piece of property. This appeal is also tied to a variance application. Off-premise signs require variance, and so this is also tied to a variance request. Specific code sections, as stated in the staff report, just want to reiterate, and I'll go through those in a second, but want to reiterate that the intent of the code is that through the letter of the Land Development Code, the intent of Section 801C2 in the Land Development Code is to maintain and ensure that all development activity is on platted property that has been subdivided in conformance with the rules, regulations, and applied conditions in the City of Lawrence as adopted by the Lawrence City Commission. It is also intended to ensure that all development activity is in conformance with Land Development Code and all other adopted codes. The term building permit refers to any development activity requiring a permit as defined, including signs. See definitions at the end of this report, and I'll go through that with you here in a moment. Just the brief history, there is an application in for a building or for a freestanding off-premise sign. It is to be located, proposed to be located at the northwest corner of George Williams Way and 6th Street. The proposed sign is, as I said, an off-premise sign. The property just north at the intersection of George Williams Way, I believe that's Rock Chalk Park Drive. Here is the business location. And if you follow my mouse, this is the corner in question where the proposed sign is to be located. Just a bit of reference for this particular area. All of this area was part of a preliminary plat process, including this large piece that is still unplatted. Two portions of this property have been final platted to date. That is this corner where the business location is located, and in this other corner on the west where there's currently some development for Lawrence Memorial Hospital. The rest of the property remains unplatted. It is unplatted property. Just to kind of go through the difference between preliminary plat and a plat, or final plat. Preliminary plat is the first step in a two-part process, and that is basically, it's a conceptual map showing where things are proposed to be located. It's reviewed in to make sure it's in general conformance with all of the subdivision regulations. A final plat is the second step in that process. That is the finalized map document showing where all easements, rights of way, proposed development activity will be located, the lots, the blocks, that it's all been done in conformance with all city codes and regulations. And that document is taken to the Register of Deeds office and recorded as a legally binding document. Some of the elements that staff used in determining or in analyzing whether or not there was an error made in the determination. One, that the property is not platted. As I said, it's part of a preliminary plat, not a final plat. That the property where the sign is to be located is not a lot of record. The application had listed or described the property by lot and block. Those lot and block references are part of what is proposed in the final plat or in the preliminary plat, not the final plat document. So currently the legal description of the land is still what is called a meets and bounds description. It is not a platted legal description. The applicant has stated that the property will remain unplatted until it is developed. In our code, constructing a sign, and by our code I mean the city's code, the city has to follow all of their adopted codes. Constructing a sign is considered development activity as defined in section 20-1701 of the Land Development Code, which requires the property to be platted. The sign proposal falls under the definition of a permanent sign in the sign code, and that requires a building permit to be erected, installed, or constructed. The applicant has stated that the revised design submittal that they have submitted, that they are willing to stipulate that there would be a removal of the sign within a 3-year time frame. That element actually doesn't impact the fact that the sign does not meet the definition of a temporary sign. The sign proposal is what is referred to as a permanent sign as defined by code, and the proposal does not qualify for any of the exemptions that would therefore be given to a temporary sign in the sign code. A temporary sign as defined by code, it references parameters for location, size, materials, maximum display period. This particular location is located in what is called a CC zoning district, and temporary signs in CC districts are only permitted for 45 days. Even if it did meet the temporary sign definition, which it again does not, it would only be permitted for an exemption period of 45 days. The sign proposal requires a building permit for the erection of the structure that is mounting the sign. It is part of the all-encompassing permit. Within the context of the Land Development Code, the sign code, and adopted building codes for the City of Lawrence, permits are defined as written authorization by the one having authority, in this case, the city. The phrase building permit, as used in the Land Development Code, does not fall within the definitions in Article 17. of general terms, and therefore that common definition would apply with specific context that can be gained by other adopted codes within the city of Lawrence, the Land Development Code, the Sign Code, and Building Code. So a building permit is the specific written authorization given by the authority, in this case, the city. The freestanding monument sign is classified as a structure, specifically by definition in Article 17. Signs are listed as structures. The structure definition is a building or anything constructed that requires permanent location on the ground or attachment to something having a permanent location on the ground, including but not limited to fences, signs, billboards, and mobile homes. Structures are defined in the Land Development Code, Sign Code, and Building Codes as adopted by the City of Lawrence and require a building permit to be constructed. So in conclusion, staff has made the determination that it did not err in determining that this property was not eligible for a building permit because it is a private property. If you have questions or need clarification or references for code sections, I would be happy to answer those.
Any questions for staff? In regards to 2017-01, general terms for development activity, any human-made change to the premises, we recently reviewed this and the neighboring lots in here. There's grading going on. Does that not constitute development activity?
This is, and that's a good point. This is very similar activity to what you recently heard an administrative appeal on. Based on your administrative appeal, the activity that is currently taking place on that property would not constitute warranting a permit of any kind at this time.
How about based on 2017-01?
Staff made the argument previously that it would have constituted a definition that is currently laid out in the code, but this board determined that it did not meet that, and so that's where we are on this particular activity. We're not addressing this particular activity tonight, but
Correct.
yeah.
Sorry, now I have a.
Yeah, sure.
That's not, the parcel where they're potentially locating the sign is not the one.
Not the one we reviewed. Is across the street.
Across
It's
the
actually
street,
directly
right?
across the street.
Yeah.
Correct.
They're dumping the materials kind of over in that area, but
There's relocation of material, grading material going
relocation,
on.
yes.
Yes.
Is the one across the street platted?
I believe that one is platted, but I would have to check that.
Okay, so that
that
might justify the development if it's platted then or something. We'll see.
I
Okay.
did not analyze that particular property in context, so
Okay.
yes.
As is my habit, I drove by the site today to look at it and noticed that there is currently a sign that is located on that property. Would that be in the nature of a temporary sign, or would it be an illegal sign?
I'm not familiar with what sign is located there. There are some exemptions for temporary signs. For instance, real estate sale signs, I believe, fall under the temporary category. I'm not sure what sign is there. If you can elaborate on what sign is there, we might
I
be able to
believe it was some type of real estate sign advertising that the land was available for
Yeah, those,
developing.
there is a code section.
Didn't read
in
it
sign
carefully.
code For real estate, that property for sale is permitted to be advertised as for sale.
it's a real, I drive by it every day. It's a real estate
Okay.
sign.
And I can get the specific code section in the sign code for you when I sit back down for the real estate sign. Any other questions?
Not at this time. Thank you.
Okay.
At this point, we'd like to hear from the applicant.
Chairperson Clark, members of the Board of Zoning Appeals, good evening. I'm Matt Goff. I'm with Barber Emerson Law Firm. The applicant tonight is a company called ILS 6 LLC. It's owned by Mr. Steve Martins, who's here this evening, and also joining us is Mr. Lance Adams with Adams Architects. I have a presentation which you have a copy of as well. And before you this evening is the appeal of the staff determination. The staff has determined that pursuant to the subdivision regulations, a sign permit cannot be granted on an unplatted lot. Our position is that that determination should be reversed. They cited 20-801C2 for authority that property inside the city limits needs to be platted in order to have a building permit. We agree. There's also 20-813E4, which says much of the same thing. You can follow along with me here, but I'm going kind of fast. A sign permit is not a building permit. Yes, we need a sign permit, but just because the property is not platted doesn't mean we can't get one. This was a tough one. We had to look at the code pretty close, but if you consider that the staff relied on section 5-139 in the staff report as the authority is saying, hey, if you want to do something, you need a permit. That's what that paragraph says. And it makes sense. But the interesting thing is that pursuant to section 5-102, it says that the provisions of this article, that would be Article 1 of Chapter 5, of which 5-139 is included, it applies to Articles 2 through 9, 11 through 14, and 17. So interestingly, the sign code, which is in Article 18, is not part of Article 1. So this section that the staff cites to say, hey, if you want to do something, get a building permit, doesn't apply to the sign code. Turns out the sign code is a body unto itself. The drafters of the city code made a decision, and the city commission who adopted it decided that the sign code should be excluded from the general building code sections that you find in Chapter 5 of the city code. I don't know why that's the case, it just happens to be the case. So a sign permit, as required by Chapter 5, Article 1804A, has, capitalized S, capitalized P, sign permit, doesn't say building permit. So you can look at 1804A, it says if anybody wants to erect a sign, you need a sign permit. Just compare that for a minute to 5-139, it says you kind of need a building permit. There's a specific section, a specific ordinance that applies to signs over the more general and inapplicable building code. The development code in Chapter 20 has a standard for how you should interpret the development code. And that's in 20-107B. Words are to be read literally. If there's a definition in Article 17, you're supposed to use it. If not, you use the standard dictionary definition. So we know that a sign is a structure. Anything could be a structure, but it's not a building. A building is something that has a roof, it's supported by columns or walls, and it's intended to be used as a shelter for something, persons, animals, or property. But it's not a sign. A sign is just a structure. So the subdivision regulations, they don't say you need a sign permit. They say you need a building permit, and a sign's not a building. You might say, well, it's an illuminated sign, so don't you need a permit to make an illuminated sign? Then one of the reasons why we came back with an all-in-one, self-contained solar sign is that you don't have to plug it in. You don't have, you see on the highway the pole with the solar array over there and the sign's over here and there's a wire. No, on this one it's self-contained right there on the same sign. Set it in the ground and turn it on. Don't need an electrical permit. So you have authority to reverse the staff's determination when you find there's substantial factual evidence in the official record, and that's what we're asking you to do. A sign permit is not the same thing as a building permit because Section 5-102 exempts the sign code from the building code We know a sign's not a building, sign permit's not a building, don't need an electrical permit, so why should the subdivision regulations, which says you can't have a building permit, keep you from having a sign? Stand for any questions that you may have.
Any questions for the applicant?
Before I'd stop, there was one part that you had, there was a question before about development activity and the need for permits, and the question came up about mining. I think the point is that not every development activity needs a permit. And when you need a sign permit, that's the permit you need. That's what it tells you it needs. It doesn't automatically mean you need a building permit, especially when you've got a section like 5-102 that defines the scope of what the building code pertains to, and it omits the sign code. I just want to say that before I forgot. Thank you.
Thank you. At this point in time, I'd like to open it up to public comment. Seeing none, I'd entertain a motion to close public comment.
So moved.
Second? Anybody?
Second.
Got a motion and a second. All in favor? Aye.
Aye.
Any opposed? All right, motion carries. Discussion?
I think he made the case that the sign code is separate from the building code, so.
May
And
staff
therefore-
answer some of the concerns?
Yeah, I'm all right with that.
So staff would disagree that the sign code is exempted from the building code. Staff would contend that the sign code is adopted in addition to the building code and all other city codes, and those references are given as context to help to understand. The applicant is contending that, obviously, the word building should be read no more specific or less to be interpreted, but applying it strictly to a building, a structure, is actually making it more specific than it is intended based on the context of the code sections that are provided. And in the context as a whole, all of the codes support the fact that building is the action or construction or a development activity as the code sections and definitions reference.
Then why is it separate?
Because there are additional requirements more specific than just are specified in the building code. And so because the City of Lawrence and the City Commission has decided that signs should be regulated, they adopted an additional chapter that incorporates all of those regulations and requirements.
Is there like a part of the law that says, states specifically?
Well, there's a mission statement in the sign code, which we can.
You said
So-
mission statement?
Well, it's like a purpose. So the purpose, the governing body finds that in order to advance the health, safety, and welfare, as well as the aesthetics of the community, it is necessary to regulate certain uses within the city, including the uses of signs. So it is adopted as a separate and additional article in the city's code with additional requirements that are not mentioned in, per se, the land development code or the building code.
So does anything in the sign code say everything applies except for this is extra?
Say that again?
Is there anything in the sign code that says everything in the building code applies, the sign code is extra?
No, but all city codes are to be complied with, and staff is presenting the case that all of the code sections in the city's code provides context for the interpretation of the building permit requirement and plating in the land development code.
Electrical permit is required for anything else.
Can the applicant's raised his hand? Can
Yeah.
he-
Do you have anything else you'd like to share, staff?
I'd be happy to answer questions, or if you need clarification.
Do we have any questions for staff at this point?
But the sign code guy may
Okay.
have an answer or something to say there.
Okay, yeah, we can hear from Barry.
Sorry. Couldn't remember his name.
Thank you, Mr. Chairman. Barry Walpole, with the City North Planning Development Services Division. I just wanted to make one comment about the need for an electrical permit. Solar photovoltaic systems do require an electrical permit. Can we pull up the Chapter 5, Article 1? Sorry about that. But the Chapter 5, Article 1 is administrative provisions of the building code that Mr. Goff was referencing as well. In Chapter 5, there's a list of, there's a general statement that permits are required, and then there's a list of types of activities that are exempt from permits. Solar photovoltaic systems are not listed as exempt. And when we look at our actual schedule of fees for permits, there is a specific fee for solar photovoltaic systems. Article 1, I can get it from there. Thank you. Apologize, we didn't quite anticipate this specific question, but okay, so it's 5-139, the same section, Mr. Goff. I apologize if I'm pronouncing that wrong. Specified building permits are required. And then 5-142 is a fairly long section, and it's a list of work that is exempt from permits. And there's a section specific to electrical work. So electrical repairs and maintenance, radio, television transmitting stations, temporary testing systems, listed cord and plug connected temporary decorative lighting, reinstallation of attachment plug receptacles, but not the outlets therefore, replacement of circuit breakers, and electrical wiring devices, appliance, apparatus, or equipment operating at not less than 25 volts and not capable of supplying more than 50 watts of energy. So those are electrical items that are exempt from permit. Looking for the schedule of fees. I think that reinforces that solar panels do require permits. Okay, under other inspections and fees, the second item up from the bottom of that table, permits for solar, thermal, and photovoltaic systems. There's a fee there for a permit that's $65. The note, the footnote there, number 3, really isn't relevant, but it does assess that fee for per piece of equipment. So just wanted to respond to that piece. We really didn't foresee that argument. So thank you. I would be happy to answer questions if there are any.
Any questions for Barry, staff? Okay, thanks, Barry.
Thank you.
Chairperson Clark, could I respond a little bit?
Is everyone all right with that? Any problems with
To open
Yeah.
it back up.
I don't
It's just,
that?
Yeah,
Okay.
we just have to open it.
Yeah, okay.
Well,
I
you're
would-
not opening
Well,
public
we're not
comment, you're just
opening.
asking, you're
Who's the
addressing the
applicant?
applicant. so-
yeah,
Okay.
That wasn't public comment either.
no,
No.
yeah.
I just want to have a chance to rebut it. I mean, I'm not disputing a word of what was just said. I just want to understand why the beginning of the sign code, everything we just read was in Article 1. The scope of Article 1 applies to 2 through 9, 11 through 14, and 17. 18 is the sign code. Thank you.
Is there any other code exempted from the rest?
What do you mean? Is there any
I
other
mean,
code exempted from the
Sign
rest?
code is not included in those, so is there any other code?
The listing of codes by articles does not exempt codes from other codes. It's just spelling them out article by category.
But it says it doesn't apply
Why?
to Article 18.
Right,
So
exactly.
what other articles does it not apply to? Maybe 10 and anything after 17, or 10, 15, 16, and then anything after 17.
What we said, 2 through 9, 2 through 9, 10 is reserved, 11 through 14, so it doesn't apply to contractor licensing, applies to trade licensing, and 19, 20.
Seems pretty clear to me. Provisions of this article shall apply to Articles 2 through 9, 11 through 14, and 17. That's
All right, we're ready to get back to our conversation here?
Yep.
Yeah.
All right. Let's discuss. Major General?
just, that 5102, to me, says signs aren't part of it. I mean, it says it applies to everything outside of it. It's- If it was gonna, if everything else was gonna apply, why wouldn't it be included?
Question for staff, where are these additional articles? I'm looking at the currently adopted construction codes.
Yeah, so this is the city code. And chapter 5 is the chapter that these articles are under.
Is there a place on the website that I can,
Yes, under the City of Lawrence, in their main web front page there, if you put in the search bar or the drop-down menu, the drop-down menu will have city code, the link there. I can back it up and show you where that is if you,
city code, there it is. This is chapter 5.
chapter 5 is building and construction, I believe.
Does anybody have any other thoughts they'd like to share at this time? Has everybody got a motion and a plan? I'm not there yet, but
I'm not sure if it was the intent, but it's kind of right there. I don't know. I'm in agreement with the general.
okay. I'm gonna try and find the actual sign code portion.
Just to reiterate, all of these articles are under the building and construction section of the city code. And every article pertains to a different element of construction in the city code. All of them are relevant because the sign code article is in building and construction, one would assume it is relevant to the building and construction and the building permit process.
I think the challenge that the Major General is facing is that there is this line that the scope explicitly excludes Chapter 18. And so for someone who would be reading this code, they might interpret that as this does not apply to Article 18.
Nor does number 19, nor does 20, nor does 21.
And so what I'm trying to look at right now, does Article 18
So
address that?
it's still a component of the sign electrical array structure. It is not just a sign.
Okay. That's a good way of stating that. Thank you.
So even by definition in the sign code, that sign is attached to a structure. That structure has a solar array. That solar array is also part of that structure and has permits associated with it.
And I think that's where I wanted to, I like that because from where I'm standing, the main question for me tonight was, what is a structure? And 2017-01 general terms for a structure, they've gone out of their way to explicitly define what a structure is. This doesn't just, we don't get the dictionary definition, but that a structure, it calls out fences, signs, billboards, and mobile homes. And so to build a structure that has a permanent location on the ground, which I would agree that this does, be it, if this even wasn't a sign, if this was just a tombstone, I'm not sure, a giant tombstone, it would require a building permit. And so I would consider that development activity. Also, like going back to 2017-01, the general term for development activity includes erection of a structure or erection of a sign. So I would say that what is going on here is a development activity because they are erecting a sign. And so I agree with the general terms and say that there is standard for building a structure. This is so long.
I also had some questions about the definition of the monument sign and how that's defined as a structure. So could you clarify where we get the monument sign definitions from?
Yeah. Do you have that handy? So monument is delineating between, for instance, like a pole sign. There are pole signs, monument signs. And is there a definition in the? I think in this context, I'm not sure, I don't remember defining monument, but it was used as a descriptor, but a monument sign is listed in the sign types as a freestanding sign. They're asking us a question.
We're allowed to ask staff a question.
Because the fact that it's a structure.
So monument sign is not defined per se. It's used as a descriptor under the permanent freestanding sign category. And it's in section 518.18.2. Yeah, and the term sign is defined, as is permanent sign and temporary sign. Under sign types, there's a table. If you're scrolling through your sign code. And in that table, under permanent freestanding signs, column, or row B, it talks about monument sign, which is a type of permanent freestanding sign mounted on an enclosed solid base or ornamental surface structure or on pole, pylon, or similar structures that are concealed with a pole cover, pylon cover, or cladding.
I didn't see it. I feel like I'm kind of rushed.
If that helps answer your question.
Yeah, and I'm looking at 539, section 5-31. Yeah, 139 saying that a permit is required to construct a structure. And although I would say my Venn diagram is that this is a structure and a sign. And so I feel like that's pretty clear.
Can I ask a question? Sure. Why have a separate section for signs then?
As I mentioned, it's because there are additional requirements for signage that are not covered in the standard building code sections.
Then why didn't they put section 18 in the?
Right.
Because it's a wholly different category, just like the electrical code, the residential code, the plumbing code, the fuel gas, or the energy code, that is under, sign code is under Article 8.
But they put all those under they put those under the scope. They didn't put 18 though.
Barry might be able to address.
Sorry, our
that
attorneys,
better.
I thought I saw, did you raise your hand? Oh, I'm sorry. So I saw-
Did you want to address that? Sure.
I think maybe I should have taken a seat at the table. Thank you for the question. I think the reason that Article 18 is excluded is that Article 1 includes administrative provisions for the application of the building codes. And those include things like appeal procedures, the appeals board, fees, requirements for licenses, and those types of, just the authority of the building department, just a lot of things that go directly to the building codes. The sign codes wanted a different set of administrative procedures that addressed how permits would be issued, what kind of variance procedures that there would be. For instance, building codes, there are no variance procedures. You can't get a variance from a building code requirement. The sign code, well, it's recognized by the sign code that there can be unique circumstances that maybe the sign regulations don't fully envision a situation. Does that help at all? I don't think there was any intent to divorce the sign code from the development regulations. I think the attempt was to create a separate set of administrative procedures for enforcement of the sign code itself.
Barry, can you address that the city has adopted the international ICC codes and that the sign code is not included in the administrative portion of this and is adopted by separate appendix?
Right. To expound just a little bit further, the city has currently adopted a set of codes, commonly referred to as a family of codes, the International Code Council codes. We've got the 2018 edition. Each of those codes has a chapter 1 that is very similar to our Article 1 of our city code. We have, in general, deleted, amended out chapter 1 of each of those building codes: building, mechanical, plumbing, energy conservation, existing buildings, electrical, I think there's a couple, fuel gas. So each of those separate codes has a chapter 1 that's very similar to our Article 1. The sign code is a City of Lawrence developed code. The building codes are national standards that we adopt by reference. So that's a little bit more background on the difference between those administrative provisions.
Thank you.
Thank you.
I would be interested if the applicant has anything to respond.
Thank you, sir. Several things. On the question of what the sign code's relevance is in relation to the rest of Chapter 5, if the drafters of this code had intended for the sign code to be everything that Chapter 5 already is and more, it could have easily said so. But by contrast, it said the opposite. It says the scope of everything over here, that's Chapter 5, doesn't apply to Chapter 18. And so the premise that you have a sign that's also a structure, and because it's a structure and a sign, you need a building permit, notwithstanding the fact that it's also a sign, you need to apply the specific part of the code first. Is this a sign or not? Yeah, it's a sign. So over the general provisions of the building code or the specific provisions of the sign code, which of the two should apply to this sign? And the answer is 18 should apply. On the question of, okay, we're in 18, that means we're not in Article 1, because anything you find in Chapter 5, Article 1 doesn't apply.
I would like to ask, can I ask you a question about that?
Of course.
Would you say, does this sign include an electrical solar array?
It does right there, yes, sir.
Okay.
And there's a code section for it right there.
And what code section is that?
5-1805. So the sign code has a section that says, the city shall also require for any internally illuminated sign, which this is what this is, for which a sign permit is sought, which is what we're seeking, an electrical permit is required. Except, however, no permit's required where you have a connection pigtail for the sign which has already been installed under a valid permit. We don't need a pigtail, so why do we need a sign permit? It'd be no different than if we were, I guess a pigtail is a plug-in.
Right.
But wherever you plug it into is already permitted. Well, if there's no plug-in, but if there's a regulation in Chapter 1 or Article 1 about voltage and whatnot, then my hang-up here, I mean, I'll be real honest. If I got to get back over here, or 102, if that wasn't in the code, my job would be so hard tonight. I don't have much of an argument without that section.
Which one?
5-102.
Two. The definition of scope, I'm sorry.
I'm not sure that I'm reading that electrical exception the same way as you are. You're saying unless,
Scope is what's relevant.
it says it's required unless it's already been done to install a pigtail. Well, it hasn't already been done to install a pigtail, and the fact that no pigtail is required
It's not.
doesn't
Don't need one.
eliminate the requirement.
Doesn't need one. Where do we don't plug it in.
I understand that.
Okay.
The definition of scope in the dictionary is,
You know, electrical permit is only defined 3 times in the code, and it's in that section I just read to you. I mean, that's an undefined term.
I honestly don't disagree with Barry. I just don't know that in this discussion it matters. I mean, it's whether or not the sign code I mean, whether or not a sign needs a building permit,
So staff would contend that it still meets the definition of development activity and that it still falls under the land development code because a permit is required for the development activity defined in the land development code.
And if there's a
And
section that
development
says
activity
any
has
development
to,
activity needs a permit.
has to comply with all city codes and regulations.
I completely understand the intent. I'm just trying to find where it is in the law. That's my struggle here. And there's no question in my mind the intent was to have the sign code, I mean, to have it be, follow with the rest of basically what's in 5. I just can't find where it's written in there. That's what I'm struggling with.
Okay, I'm going to try and keep the conversation discussion up on this end, and we can ask questions of the applicant or staff, just for sanity's sake.
So the definition of scope is the extent or area of the subject matter, something that deals with or to which it is relevant. And that says it's not relevant. The rest of it's not relevant. That's what scope means. So if it didn't say that, this would not be an issue. But because it says that, it is the sign code that is what we have to go by. If it didn't say that, we wouldn't be here.
I think, yeah. Anybody else want to speak to this?
Well, 5102 is there for a reason, and the only reason it seems to be there is to call out the application.
So then under this loophole, any unplatted lot, they could just pop up signs front to back, left to right?
With the sign permit
Until they fix the
provided
law.
by the sign code. Because the sign code is what applies. You want me to make a motion and then just vote on it and be done?
Yeah, that'd be nice.
Okay. I move that we reverse the, what is it we're reversing?
You'd be moving to,
Moving that the staff erred.
yeah, that staff erred.
I'm moving that the staff erred based on the finding that Section 5102 that describes scope does not make the sign code relevant to the rest of the code. And therefore, it's the sign code that applies.
Okay, we got a motion.
I second.
Second. Motion and a second. All in favor?
Aye.
Can you show of hands, please?
All opposed? What's that mean? Motion failed to carry. Okay. Just go back to discussion?
Or you could propose another motion?
Propose another motion. if we find this in error, then the sign has to come before the sign code next, right?
No, I think if we, yeah, if staff erred,
Right.
Then we would-
Then we do the next one,
Yeah.
which is the sign code variance that they're asking for.
Correct.
Right. So then we're saying the sign code applies, and we're going to look at it as a variance for the sign code, not the building code. Is that correct in my understanding? Yeah, okay.
So the provision that the motion is made under is under sign code, but we're looking at it under chapter 20 also, the land development code. So they're working hand in hand, so I think that all the codes work together, like staff is suggesting.
The appeal here relates to whether or not this is a structure such that a building permit would be required. So that really has nothing to do whatsoever with the variance or the sign code. The sign code will come up, and that will be a separate decision later. This has to do related to a determination by the planning director that the building code and the building permit required to the structure involved here, or the sign, however you want to
So
declare it.
if we say a building permit is required, we are basically saying we're deciding that 5102 is not applicable. It means we ignore it,
so I think
right?
where I was going was, I would agree with that, except for if it needed an electrical inspection.
Okay, but that's addressed under the sign code.
And that's kind of where I'm at right now, but it's just like, are there, while this does have that 18, is there something in Article 2, 3, 4, 5, 6, 7, the ones that are in scope that do apply to this that we need to consider? And so, yeah, the things, because it's a sign, there are certain things that are out of scope, but because it's also a structure, we need to include it.
And because it's a structure, it requires a permit.
And because it's a structure, it requires a permit. And so just because it is a sign doesn't also mean that it might not other things. Like, it'd be a shame if I could just call my house a sign and say, like, I'm gonna build a sign and I don't need a permit for that because it's a sign.
I have a question for Barry.
We have a question for staff.
Yeah. How many times when somebody was building a sign did they have to get a building permit before they got a sign permit? Has it ever happened, and when was it, and what was it, if you can remember any of them?
It's not uncommon for electrical permits to be associated with signs. I don't recall an instance where a building permit was issued. Well, there
Or
may
a
be.
structure, they're building a structure, so they're getting a building permit, and then they get a sign permit.
Yeah, no, well, actually, that happens all the time. Anytime you build a new building,
Right.
it's not a residence, that's one or two family residence even. Almost 100% of those have signs on them. This exemption from an electrical permit that Mr. Goff talked about, the intent of that is, or what it says, is that if you're putting up a sign and the electrical branch wiring has already been provided for that sign, then a separate electrical permit's not needed. If the electrical wiring is not already in place for the sign, that's when the permit's needed. So in this case, there may be a little bit of confusion here, but it's self-contained, yes, but it is a solar panel, and that falls under not only Article 1, but Article, I believe, 4, which is the electrical code. That those solar provisions are covered by the National Electrical Code, which we've adopted by reference in Article 4.
Okay, so if this had no electrics, it's just a monument sign, would there be a need for a building permit separate from a sign permit?
No, the sign permit would be the only permit needed.
Okay.
And
So there's no structure requiring a building permit that's also a sign, that's not lit?
This is a structure. It is a structure that requires a sign permit. Yes.
if, Dimitri,
I'm good.
if the land was platted, let's say this was somewhere in a more developed part of town, and they were introducing a standalone solar sign, would that also require an electrical permit? Since there is no pigtail or whatever that it's already tying into,
Yes, if this were a platted lot and were a sign that was an on-premise sign and met all of the sign code requirements, 2 permits would be needed, a sign permit and an electrical permit.
okay, and that's where I can't get past, where it's like, I understand that it's a sign, and I don't 100% understand this, but hearing from staff that they would require an electrical review, even if it was platted, that puts it into, it's like, it's 18, which isn't in the scope, and also, oh my gosh, this is so long, Article 4, which is in scope.
Staff, you said that the preliminary plat has been done. When is the final plat happening?
There's no plan for the final plat in the immediate future. It could be a week from now, it could be 3 years from now, we don't know that. That's up to the property owner.
They said they don't intend to do a final plat until it's developed, or going to be developed according to the materials.
Thank you, Barry.
Thanks, Barry. I would entertain a motion, or I'd be happy to make my own and see if it changes things. But based on conversation with the staff there, I believe that staff did not err, and that this sign, having the need for an electrical code permitting and review, does fall underneath the scope of Chapter 5, Article 1, and therefore does constitute or count as being a development of a structure, and therefore does require a building permit. Second?
So again, just to be clear, the way you worded your motion, you would be either upholding staff's
Yeah,
determination?
we would be upholding based on
Okay.
that scope.
An electrical permit is a building permit,
Electrical is development.
but electrical permit is a building permit.
But no building permit should be permitted on unplatted land.
Yeah, that's that matter before you.
And an electrical permit is a building permit?
Staff did make the argument that building permit encompassed all forms of permitting, yes.
Okay. Okay.
So is there anywhere that the strength or voltage of the what?
Solar,
Yeah, the solar. Is there anywhere that states if it's below a certain amount of a strength or voltage, however they define that?
oh, it is in the,
Yes,
It was like
there is an
50
exemption.
watts.
Excuse me while I find it.
Sorry.
No, that's fine.
I think it was 50 watts.
Okay.
Yeah, there was both a voltage and a wattage, and I do not have that memorized.
The applicant know what the voltage is of your solar?
We're almost there.
Scroll back up.
Solar irradiations for Lawrence, Kansas would not allow for anything greater than.
Okay, so electrical wiring devices, appliances, apparatus, or equipment operating at less than 25 volts and not capable of supplying more than 50 watts of energy. We do not have that information that I'm aware of. I think I just need to leave it right there. I was about to say something I didn't know was accurate, so
That's why,
we just don't know what that is.
so that's why I was asking the applicant.
That's good. Yeah, that's good.
Do you know what the wattage/volt of the solar array are?
Commissioner Gardner, we don't have that information, but for sake of clarity, if your motion could specify whether the electrical part is influential in the determination by staff, then that gives us something to think about.
Mm-hmm. Okay.
Oh. Okay. Can I try another motion, or do you want to vote on your motion?
No, my motion's
Okay.
gone with the wind here.
So,
Does anybody want to discuss?
I'm sorry, did you just say you were withdrawing your motion, or?
Yeah, I'm sorry. I assumed that after a certain amount of time, motions just disappeared.
No.
So,
You have to
okay.
withdraw your motion.
My motion is withdrawn due to the conversation and more finding a fact. Would anybody like to discuss based on conversation from Barry and the applicant?
so, how the heck do I make that motion? So, I'd move that the
We can stipulate to be under that voltage.
Yeah, if, I think that's what
And
that,
that's basically, it's a monument sign.
Again, the matter before you is strictly whether or not staff erred in their determination. We're not negotiating design
oh, yeah, that's
options.
right. Oh, yeah. Oh,
This
man.
information would have been needed to
Okay.
make the determination. Right?
It's a yes or no.
Yeah. That's an interesting point.
I think we already took our vote unless there's been any information that would make anybody want to reconsider.
That motion didn't carry, though. The earlier vote
Right,
didn't carry. We have to reach a decision, correct? Yeah.
I'll make a motion
Okay.
that staff did not err when it issued its determination. Is that enough?
We have a motion. Do we have a second?
I'll second it.
Okay. We have a motion and a second. All in favor? Aye. All opposed? We're still a standstill.
In case you're deadlocked and there's some absences, would you be willing to defer it till you have a full board?
I'll open that up to discussion. I don't know if that's something we'll consider. Thank you.
We're okay with that.
Can we table it?
This is the only agenda item. Yeah.
We'll have to see if you are able to defer prior to, once the meeting has begun. Hang on just a moment.
When will we
That's
have
not-
that
That's-
decision?
I'm looking right now.
Okay.
Yeah,
Yeah,
I have to leave in 6 minutes, that's why I'm asking.
yeah, that's,
And I don't think that's fair to anybody involved.
I think we can table.
I remember the applicant couldn't defer it once it started, but I'm not sure about the board itself. It seems like the board could do that if they wanted to.
Well, I think it would be a motion to table, so we're not really deferring it. We're
Right.
just,
Tabling it, and,
Yeah, I don't see that specifically addressed in the appeals section.
okay. Move we table it.
I'll second that
Do we need to table it to a specific date?
till the next meeting.
Do we need to be that
Well, is that
specific, or can we
acceptable?
just table it?
Huh?
Do we need to be that specific, or can we just table it and that's okay?
it's a question for staff.
It does, I don't see anything about tabling in the determination item.
I think if you're gonna wait till you have 7, you're gonna have to hold the hearing all over again so that the member who's not here.
Right.
Basically, what I think probably the best thing to do if you want to carry it over to the next meeting or the one after that would be to just keep the meeting open and rehear the evidence at the next meeting. Some type of
Okay.
motion like that.
So we wouldn't close this meeting.
Correct, this
We-
hearing.
We would add another player in when we check the quorum and then do it
Right.
again. Okay.
If
Or,
that's okay
or
with
when
the
there's an
applicant, the
odd
applicant would
number of
have to
people
agree to
that show up.
We couldn't force it on the applicant would have to agree to that.
Oh, okay.
Question then is begged, what would happen if one of you were not here at the next meeting, or for some reason we had a different arrangement of commissioners?
Do you have a motion to table it?
A motion to, well, to leave the meeting open.
Public hearing item
Pu-
open. Table until the next meeting where there's 7 commissioners.
7 or an odd number so that a decision can be made, yeah. Doesn't have to be the whole, because that doesn't happen every time.
Okay, we have a motion. Do I have a second?
Second, yep.
All in favor?
Aye.
Aye. Any opposed? Okay, motion carries.
That means the same thing happens with the signboard, because the whole sign
nothing
thing,
else to talk about.
We'll get,
there's nothing to talk about.
we'll get there, yeah. We have a miscellaneous agenda item this evening. It is KOMA training. Does that agenda item still stand tonight?
I'm heading out.
Okay.
Sorry, guys.
I just can't get past that. It
You
is.
know, it might be perhaps a good idea maybe to adjourn and then adjourn the sign code so you can perhaps defer the next thing, and I can give this presentation to you as
sign code?
/ yeah, BZA board, and then these guys could get out of it.
Okay. Okay. Then I would move that we postpone KOMA training to be part of our sign code variation. Do I have a second?
Second?
All in favor? Aye. All right. Then I would move that we adjourn the Board of Zoning Appeals.
Second.
Second, all in favor?
Aye.
Aye. All right, meeting adjourned. Should we have a short break now, or
The applicant may know their determination, then they be able to.
would you like a short break to discuss?
Thank you, Chair. If it pleases you, we would just defer on the variance too.
Okay.
If that's all right with the signboard.
Okay, so you don't need any time? Then we will convene this Board of,
We'll need to take roll again.
okay, and we will take roll,
Yep, just quickly.
as we've had a shift.
Clark,
Present?
Alvey,
Present.
Gardner,
Here?
Harrod, Shalinski,
Here.
Wampler,
Here.
Weisner. Okay, we still have quorum.
Great. Item number I, communications before the board. Do we have any communications to see tonight?
No, we don't.
Do we have any disclosure of ex parte communications or abstentions?
No.
Seeing none, are there any agenda items that will be deferred this evening?
We do have one by the applicant who's wishing to defer until the meeting that there are other items on.
Great. Seeing that is the only agenda item this evening, we'll move on to K, Miscellaneous, for which we have a deferred annual KOMA training.
Sounds good.
So do we have to be in session to get the training?
You're still in session as a sign code board. You can have the training under other board.
Oh, okay.
And so have you deferred the variance?
Has been deferred.
Okay.
Thank you.
Thank you.
I understand. Good evening, everybody. Randy Larkin I'm the Deputy City Attorney with the City Attorney's Office. Annually try to give KOMA training and conflict of interest training. So tonight we're going to go over that. It's not the most exciting subject in the world, and don't have a PowerPoint because I don't know how to do them. But I'm going to go through it, and it's not exciting stuff, like I said, but it's important stuff to hopefully keep you out of trouble, keep the city out of trouble, and just kind of give you an overview of what open meeting rules are about and what conflict of interests are. And so if you have any questions or want to make this more interactive, the better that will be for everybody. So as we go along, you have a question, just shout it out and we'll go from there. The Open Meetings Act was enacted in 1972. It came out of a lot of period of reform in the 50s and 60s in government. It's basically aimed at keeping government from doing business behind closed doors. The thought is that, the cornerstone of public access to local and state government, and it's basically to require all the governments to do the business of the public in the view of the public, because an informed electorate is a good electorate. That's basically the purpose of it. And it's of such concern to the state, and they treat it seriously enough that the courts, when confronting a KOMA case or an Open Meetings Act case, will construe its provisions liberally and any exceptions narrowly. So basically, if there is a benefit of the doubt to be given, it's going to go against the board. So just to give you a heads up. Now, KOMA applies when two criteria are met, just two. The governmental entity is covered, and when the covered entity conducts a meeting. So there has to be a covered entity, there has to be a meeting. Covered entities are any board or any subdivision of the state that receives money from the state. Both the city and the county, who you are a subdivision of, receive money from the state. So it's clear that the Board of Zoning Appeals is a covered entity. So that one we're not going to discuss too long. The question of whether it's a meeting, that's what always comes up. So for there to be a meeting, there has to be three things that apply. It has to be a gathering or assembly of persons through any type of media. It could be in person, could be over the telephone, could be a chat room, could be a Skype. However, whatever there's a gathering or assembly of the members of the board by a majority of the members of the board. There's 7 members of the BZA, so if there's 4, it could be a meeting. If there's 3, it's not a meeting. So, like I said, gathering or assembly of 4 or more, and you discuss the business of the BZA. So, that's it. 3 things. It has to be a gathering or assembly or some type of intercommunication through whatever media by 4 of you to discuss the business of here. And the purpose of that is to keep you from discussing things that are coming before you, making the decision before you get here, and then coming out and just making your decision. So I'll go through each of those a little bit more detail. A gathering or assembly is like what we have tonight when you're in presence of each other. Could be if you guys go to dinner together. If you have a social gathering, those would all apply. Telephone calls, like I said, Skypes, video conferencing. One thing to be aware of can also be emails. So if there's an email coming out and someone has a question about something that's going to appear before you, please don't hit reply all, because then that could trigger it as being a meeting or a gathering of all of you. And what they call that is sometimes a serial meeting. I'll go into that a little bit later. And then, again, like I said, there's 4 people. And then, so I don't need to go into that anymore. It just applies if there's 4 of you. And then discussing the business or affairs of the BZA. This basically involves something that is before you or will be before you, any of those types of things. It doesn't apply to procedures like how do we order the agenda or that type of matter. It doesn't apply to that, but it applies to those substantive matters that apply. You have a social gathering. It doesn't apply until if you talk about the business, you're in trouble. You guys can all attend a conference together as long as you don't discuss anything that's appearing before you. Those are all appropriate. One thing to be aware of is a serial meeting, and what this prohibits is one member of the board saying, I don't like this project, or I don't like this variance, sending it to another commissioner who then forwards that to a third one. Once that hits 4 people, that is a serial meeting, and that is a problem. I know that Johnson County, one of the Parks and Rec board over there got in quite a bit of trouble because they were making decisions by chain emails, and anyway, it was kind of a serious deal. So avoid doing that. Now, doesn't mean you can't communicate with each other, but just don't say, Commissioner, or, one of the members said this to me, and then have that go to a 4th person, because that could very well be considered a meeting, is once you start conveying what each of you say to each other. So be careful about that. Also, like I said, be very careful about hitting reply all, because that could trigger all of those things apply.
Question?
Yes.
Does the business of the board, does that entail future business of the board or even past business of the board?
Past business is not as big a deal. I don't know that it would be a problem, because it's not really once you reach the decision to discuss about a past decision, to the extent that it doesn't reflect on something that you're going to be doing currently or something you're going to be doing in the future. So, if you could say, well, I maybe didn't like my decision in a particular case, or maybe we could have handled something a little bit differently. I don't know that that's a problem, but it's typically things that are going to appear before you, or things that will appear before you, or even anticipating things that might come up. That's the business of the board.
So if I host a party, I need to do it right after the board meeting, before the next thing comes out.
That's right.
That's right.
You can talk about what you did that night, yes. Just don't talk about what you're going to be doing in the future.
To include the staff, so that they don't hate me because
Since its purpose is to ensure that the public business is discussed, one of the things about open meetings, you have to give adequate notice. If an agenda is prepared, it's not required, but if it is prepared, it has to be made available to anyone upon request. I think the secretary we handle that in here, so you don't have to worry about that. Must be held in places that are accessible to the public. You can't adjourn way upstairs behind locked doors, or where it's inaccessible to other people maybe who have a handicap or something of that nature. So since we're in this room and it's readily accessible, that's fine. If there is a problem, then this is where the problem, if there is a violation, there's various things that can happen. Any person who thinks they've been hurt or aggrieved by it can bring a private cause of action against the BZA, the city, or the county, or however it works. The district attorney and the attorney general both have the authority to enforce KOMA against the Board of Zoning Appeals. And remedies might include injunction, mandamus. There's civil penalties for violations that may come out, the payments of the cost of damages, and appropriate orders. The court may just nullify any decision that you made and order it be done again. If an action is brought, just to give you an idea how serious the state takes these, if an action is brought for violation of the Open Meetings Act, it will take precedence over other things that the court has. They will have to move things to hear that within a certain period of time to get that before and make a decision on it, just to show you that. The penalties for any violation that might be determined by the court is an action may be voided, like I said. There's a civil penalty of up to $500 per each of you per violation. And that, let you know, only has to be a knowing violation. They don't have to prove specific intent to violate the law. You just have to know that you engaged in a communication regarding the business. It's not that big a threshold, so you don't have to they don't have to prove that you intended to break the law, just that you knowingly engaged in the behavior that created the violation.
Question there. So
Yes.
that means that somebody has an email conversation with the first person, that person has a second with the third person, that one does it with the fourth, so is it all four?
Yeah, I'll be all for it because you knowingly spoke to the next person thinking that, with the perhaps it being foreseeable that that might be communicated to somebody else, since you knowingly talked about it. I mean, the situation that would come up where you were knowingly, perhaps you're on some type of medication and you just go a little bit wild and start talking and you don't remember it or can't establish that you did it out of your own free will. But if you knowingly make the communication and that leads to a serial meeting or leads to any other type of violation, that would be a knowing violation.
Even though it wasn't when you did it?
That wasn't your specific intent, and there was no intent, right? It's just a knowing violation.
Wow.
The court may also enjoin your action, issue a writ of mandamus, and again, like I said, the costs may be enforced against you. Really what would probably happen, unless it's an egregious deal, the Attorney General will come down hard on us, make you all go to class, and probably get your names in the newspaper. That's basically what's probably going to happen, but it's still kind of embarrassing and no one wants to go to those classes. So if you ever have a question regarding any of this, feel free to contact our office. We can give you advice as to what to do. We have to deal with this with the city commission, with the planning commission, and various things. So that's why city commissioners are always discussing whether or not 2 or 3 of them can appear at a function. So anyway, that's the Kansas Open Meetings Act. Any questions before I move on?
No.
All right. Conflict of interest. This is when you would abstain or not abstain, and the penalties here are a little bit stiffer than violation of the Open Meetings Act. The conflict of interest laws goes back to basically the same Reform Act, and the purpose of the conflict of interest laws is that so nobody uses public office to better themselves for private gain, basically is what it is. You can't use your office for private gain. As appointed members of the BZA, you are considered local government officers, and the state conflicts of interest laws apply to you. Now, basically what it does is if you have a substantial interest in anybody appearing before this board, then you'd have a potential conflict of interest. And there's 2 things that you can do to avoid that. If you have filed with the county election board, or officer a statement of substantial interest, then you can actually participate and decide a matter involving that person. Or if you have not, then you must abstain. And by abstaining, you have to declare your abstention ahead of time. And basically, we then would ask you to leave the room and go wait in the back room until that was decided.
Can you define substantial?
Yes, there's various different things. So that's how you avoid getting in trouble, is either file a statement of substantial interest or abstain. Now, the question then becomes, when is there a substantial interest? And the state statute provides basically 5 things. If you or your spouse or significant other have collectively owned within previous 12 months a legal or equitable interest in anybody appearing before you exceeding 5% or $5,000 of any business, whichever is less, then you have a substantial interest. So if you own $5,000 of stock in AT&T and they appear before you because they're seeking a variance for something, then you have a substantial interest in AT&T.
So
Something
tonight,
to
it
work.
would have been $5,000 in Best Western stock
Right,
or
if you
something?
had $5,000 in Best Western stock, unless you listed that on your statement of substantial interest, you would have a substantial interest in that business. Now, if there's a local business and you own half of it, and that business is here for a variance, well, I mean, that's pretty obvious, but anyway, that's what triggers it. That's what the statute that causes that.
When I worked in the Department of Homeland Security, we had to fill out a statement that basically showed everything that we owned, and then it was reviewed by council. We don't do that.
No,
So
that is.
you would have to basically know ahead of time somebody was coming and then do that substantial interest thing, or.
Right.
You would realize that maybe you have a substantial interest, and that's why we have the moment where, at the beginning of the meeting, you can abstain from any items.
And, you know, I know some of the city commissioners, when they stand for election or run, they'll file their statement that, yes, I own this business, I have this stock, I own this property, and then that way they can either participate, sometimes they will abstain anyway, just to avoid an appearance of impropriety. But anyway, if they were to participate without that statement, then they would be in violation of this law.
So is the statement public, made public?
It would be a public record, but they keep it down there, yes. The other option, of course, is to just abstain.
Right.
If you have received during the previous year $2,000 that you would have to report on an income tax. So if your business that you work for paid you or your spouse or significant other more than $2,000 in the previous year, and you had to file any taxes on that, then you have a significant interest in that entity. If during the previous year you've received more than $500 in gifts or something of that nature without having given any consideration for it, you would have a substantial interest. You win a $500 shopping spree at Dillon's, you have a substantial interest in Dillon's for the next year. So those are the kinds of things you have to be aware of. If you are an officer or hold a position of trust, you're on a board of trustees for some type of entity, or your spouse or your significant other, then you have a substantial interest in that company. Now, there is an exception for not-for-profit. So if you're on the board of the Boys and Girls Club or something that's a registered 501c, 501, whatever, all those types of corporations, that's okay. But if you're on the board of directors of something else that is a for-profit corporation, then you basically have a substantial interest in that business. And the fifth one, if you receive commissions in excess of $2,000 or your spouse receives commissions in excess of $2,000, I think the best example is if you're a real estate agent, you sell some property for somebody and you receive more than $2,000 in commissions for that sale or brokeraging a deal, it could be a stockbroker, then you have a substantial interest in the company appearing before you.
I've been on lots of nonprofit boards, so if we were on a nonprofit board and then I'm not on that board now 2 years later, and the entity comes in here, is that a?
That is not a problem. Even if you're on the, let's say the Girls and Boys Club, even if you're on that board and they appear before you, you're exempt from that.
Oh, okay.
So, like I said, you file a statement of substantial interest with the county election officer down at the old courthouse. They have a form for it. You just put your name, fill all that information. If you do not file that statement, and if you do not abstain, and you participate in something where you do have a substantial interest, it is a Class B misdemeanor if you're convicted of that. Penalties include up to 6 months in jail and a fine not to exceed $1,000 for each violation. So it's actually a crime as opposed to a civil violation under KOMA. So that's the serious ramifications of that. If you have a question, there is a government ethics commission in the state of Kansas. You can ask for an opinion. They will give you a written opinion regarding something if you have a question. And if they are wrong, you have immunity. So if they tell you that you can participate in this matter and it's later turned over and said, no, you couldn't do that, you have that letter, it's immunity. And there's address and telephone numbers in Topeka. You can contact us. The other thing you can do is always ask us. You can run it through the planning department. Contact me directly. I think maybe in the papers I gave you, my number's in there. But we're here if you ever have any questions regarding a substantial interest and conflict of interest, because we don't want to get anybody in trouble. And sometimes we'll just say, you know, maybe just an appearance of impropriety, maybe you want to choose to abstain here. It's your next door neighbor who you go over a couple, you know, 2 or 3 times a year and have a barbecue. You may not want to be dealing with ruling on their variance request, for example. You wouldn't necessarily have a conflict of interest, but there may be an appearance of being unfair, or not to mention maybe perhaps causing hardship and hard feelings between you and your neighbor. So that's it. Any questions regarding conflicts of interest and any of that? We do have, I'll just point out briefly before closing, that we do have a new city ethics policy. I think it's pretty straightforward. It was adopted 2 or 3 years ago, and it makes basically, it states that, you know, if you use your position for your own benefit, then that's a violation of the city ethics policy. I'm not going to go into any details, pretty straightforward. So,
I get a lot of good stories out of this.
yes.
Is that okay? Like,
Yeah.
telling other people and getting a good laugh? Like,
Sometimes.
I benefit out from that.
Yes. And then I don't have anything on the bylaws. I just would point out when we do abstain, it's best if you head out. So there's been some people that have gotten in trouble for sliding into the back of the room and other places and giving signs and doing things like that to the other commission to avoid, you know, they've abstained, but they're still giving it. And if you start hearing a matter, you need to vote on it at the end. So those are the only 2 things I would mention regarding the bylaws. Otherwise, they're pretty straightforward. So, any questions?
The last one is, I've always abstained when we're approving the minutes, if I wasn't.
That's perfectly fine.
Okay, all right,
That's perfectly fine. So, and there's no need to leave the room on that. That's your.
okay.
Yeah, and abstention in that case is perfect. That's the right decision.
Okay, thanks.
All right, well, thank you. And anyway, I also want to thank you for your service and everything you do for the community. Very appreciated. Sometimes it's a thankless task, but we do thank what you do, or we are appreciative of what you do, and thank you.
We like what you do too, Randy. Thank you.
Yeah.
All right. Seeing no other miscellaneous items for the sign code, and having lost our agenda here, I believe
Last item.
that was the last item. So,
Arranged, you would just have miscellaneous, which we do not have any. Typically, I would update you as to whether or not we have any items that may be coming before you in March. Tomorrow is our deadline for 3 p.m., and so we may have one at this point. We'll know more tomorrow, but we'll try to give you a heads up if for some reason we're not going to have a meeting.
great. Then I would entertain a motion to close the meeting. Motion? Second?
Second.
All in favor?
Aye.
Aye. Meeting adjourned. Thanks, everybody.